Welcome and thank you for joining Seyfarth's webinar, Deciphering the FTC's Non-Compete Ban, Navigating the New Regulatory Terrain and Adequately Protecting Employers' Interests. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Robert Milligan. Robert, you may begin.
Thank you, Joan, and thank you, audience, for joining us for today's webinar. I'd like to introduce you to today's panel for our hour-and-a-half webinar. Next slide, please. We've gathered together a group of cross-practice panel from a number of our offices across the United States. I'm joined by Michael Wexler, who's the co-chair of our trade secret group in Chicago. I'm also joined by Kate Pirelli, who's also a co-chair of our trade secret non-compete practice in Boston. We have our chair of our M&A practice, Susie Saxman, based out of Chicago. Harry Burke, who's one of our labor partners based out of Atlanta. And then finally, Mark Foss, who's based out of San Francisco, is one of our employee benefits partners. I'm based out of Los Angeles, and I'm the co-chair of our trade secret non-compete practice. Next slide, please. Wanted to briefly go through with you our agenda that we're going to be presenting on today. As Joan mentioned, at any time, if you have any questions, feel free to use the Q&A. We'll try to address your question as appropriate, and we've allocated some time for Q&A at the end as well. We're going to be talking about the momentous event of the FTC's non-compete ban. Get into a little bit of the background and the context. Kate and Mike are going to address the nuts and bolts of the FTC rule and the implication for employers. In gathering our cross-practice group, we're going to have Susie get into the impact on M&A and Mark get into the impact on employee benefits, and then try to come together with some strategies and solutions in dealing with this ban. And then finally give you an update about what's going on the legal challenges to the ban. There's been 3 lawsuits that are filed with 2 injunctions sought in those lawsuits. And then finally, as I mentioned, we're going to have a Q&A session. Next slide, please. Let's get into our first topic, which is the background and the context of the FTC's ban on non-competes. Next slide. The non-compete ban and the rule was announced last week. Along with the ban, the FTC issued a press release laying out their reasons for why they thought that the ban was appropriate. Fundamentally, they want to protect workers' rights to change jobs. They feel that the ban will increase innovation, and they also believe that the ban will foster new business formation. As you can see, the FTC chair, Lena Khan, was quoted as saying that she thought that this will lead to the more startups once the non-competes are banned, and give workers new freedoms that will move the economy, move the needle with the economy. Ultimately, what the FTC had to do in reaching the ban is that they needed to conclude that non-competes were an unfair method of competition under Section 5 of the FTC Act, and that's exactly what they did. As far as the timing of the ban and what employers are going to have to do, the deadline to that the rule goes into effect is September 4th, and it's tied to when the rule was published in the Federal Register. It's scheduled to be published in the Federal Register May 7th, and so that leaves us with a deadline of September 4th for when it goes into effect. Next slide, please. And so how did we get here? I think we wanted to give you a base, a backdrop of, this didn't come out of thin air. This is something that the Biden administration and the FTC has been working on for a few years now. And so we wanted to give you a brief overview of how we got to where we're at before we get into the nuts and bolts. So with that, I'll turn it over to Carrie, who give us a background on how we got to where we're at.
Thanks, Robert. Next slide, please. So briefly, here are the justifications for the rule, which Robert really went over in broad strokes already. The whole point, according to the FTC, of banning non-compete clauses is, go ahead. Is to boost wages, spur innovation, and invigorate the economy. And the predicted outcomes of the ban are purportedly to increase business formation, as Robert mentioned, and raise worker earnings, which has been a broad goal of the Biden administration. So let's go to the next slide, please. So let's take a brief history lesson. How did we get here? Well, first and foremost, the Federal Trade Commission Act is a 110-year-old law at this point. It was enacted under Woodrow Wilson right around the time of World War I. And the goal of the act at the time was to curtail monopolistic practices. 100 years later, 106 years later, really, then enters then candidate Biden, who, as part of his broader pitch to be the most pro-labor and pro-worker president in the history of the United States, set out this overarching goal to eliminate non-compete clauses as well as no poaching agreements. And the point behind that is, in his view, such agreements, when applied to a broad swath of workers, hindered workers' ability to seek higher wages, better benefits, and also to better their working conditions. After becoming president in July of 2021, two things happened on the same day. First, the president issued an executive order, quote, promoting competition in the American economy. And this basically set out this notion that he laid out as a candidate, which is he is going to use all of the levers available to the president of the government to take this whole of government approach to promoting competition. And that very same day, the FTC, as part of this whole of government approach, withdrew a prior statement of enforcement that had been effective since 2015. And effectively, that pronouncement that occurred in July of 21 withdrew what was called the rule of reason and set out a whole bunch of different ways in which the Biden administration, in broad strokes, viewed unfair competition beyond these monopolistic principles that were the sort of the bedrock of the act in 1914. So let's move to the next slide, please. Fast forward about a year and a half later to November 10th of 2022, the FTC sets out this new policy statement after President Biden has found a way to turn the whole of government around. As we all know, it takes a long time to turn a boat. So this policy statement in 2022 even pushed aside an Obama administration recitation of enforcement principles that really limited the application of Section 5 of the Act to adopt a much broader approach that was based on the FTC Act's legislative history. And according to this new policy statement, Section 5 gives the agency a broad mandate to challenge conduct outside of the bounds of the Sherman or the Clayton Acts, which, as we talked about just previously, was the whole basis of the FTC Act in the first place, to target monopolistic practices. A couple months later, our worlds all shook in January of 2023 when two things happened within days of each other. The first is on January 4th, the FTC announced settlements with three employers wherein the FTC alleged that these employers illegally imposed non-compete restrictions on workers. The next shoe dropped the very next day when on January 5th, the FTC issued the notice of proposed rulemaking on worker non-competes, which has evolved in what we are seeing and discussing today. Next slide, please. So consistent with this whole of government approach, the FTC is not the only government agency that has taken a significant interest in the application of non-competes to workers. In February 21st of 2023, the NLRB, the National Labor Relations Board, stepped into the fray and issued its McLaren-McComb decision. Some of y'all might recall that In that decision, the board basically set out its position that employers cannot tie workers, so non-supervisory employees, to confidentiality agreements or to severance or separation agreements that would contain broad confidentiality provisions that, as an example, would prohibit employees from talking about the existence of the agreement, as well as would prohibit employers from tying employees to broad non-disparagement provisions. And McLaren-McComb essentially evolved into this platform from the National Labor Relations Board's General Counsel that non-competition agreements as applied to non-supervisory employees are in broad strokes unlawful. So this idea from the General Counsel was first introduced in March of 2023, and all of us labor practitioners sort of scratched our heads and said, how is this going to play out in practice? And then in May of 2023, we got this NLRB memo guidance, wherein the General Counsel explicitly set out her view that non-competes as applied to non-supervisors are unlawful under the National Labor Relations Act. And the basic theory of that is a non-compete for a non-supervisory worker would chill that worker potentially, from wanting to move on to try and find another job because they may be ultimately gone after by their employer for violating their non-competition agreement. Now, this has not stayed in the ether as pie in the sky either. What has happened is several complaints have issued from the General Counsel's office against employers who have laid out pretty standard run-of-the-mill non-competition agreements with their non-supervisory employees. We have not gotten any decisions from either administrative law judges or the National Labor Relations Board itself yet. Rather, the employers who have faced such complaints from the General Counsel have turned over and settled. And that leads us to April 23rd of 2024, wherein the FTC issued its final rule on a 3-2 vote. And at this point, I will turn the mic over to Michael and Kate.
Great, thank you, Carrie. So what does the rule actually prohibit? Everyone has a lot of questions about that. We're going to try and go over the broad strokes here so everyone understands what the rule actually says. But let's be very clear about something. As of right now, the rule is not in effect. There's the waiting period after the Federal Register publication. So the rule cannot go into effect prior to the September 4th date that Robert mentioned a moment ago. So the question becomes, what does the rule entail if and when it goes into effect? And we'll ultimately get to some answers to questions about what should employers be doing, if anything, right now. And my colleagues will get to that. But right now, stay calm, because there's no rule, there's nothing that's prohibiting non-competes yet, other than state laws, which obviously differs in every state. So what does the rule prohibit? Next slide, please. Next slide. So the rule basically prohibits all non-competes for employees, for workers in the United States. That means that if you are a worker, that means you could be an employee, you could be an independent contractor. It doesn't distinguish between the two, meaning if you're a worker in the United States, you can't have a non-compete if the rule goes into effect. They look at that, and by the way, the rule is 570 pages and has all kinds of discussions and all kinds of scenarios, convenient questions that the FTC said, oh, we were asked this, and here's how we answer it. And of course, they're very favorable to the way that the way the FTC wants us to come out, that all the answers to the questions are basically, yeah, the rule applies. But in any event, when we look at this, there's situations where a restriction, let's call it, on someone's employment or a term of their employment could also be a restriction, such as where you have a provision that says you forfeit compensation, or you have clawback, meaning you were paid something, given something, could be equity, some kind of shares, RSUs, options, etc. And those things are forfeited or clawed back if you compete. That's also seen as a non-compete, even though there may not be something that says you can't compete. There's a penalty for competing. So the FTC's view is that serves as a non-compete, so you can't use those. The rule also then, though, doesn't apply to non-disclosure agreements, non-solicit agreements, unless, of course, in the FTC's view of this, it functions to serve as a non-compete. So, for example, if you had a confidentiality provision that in some way was so broad that it restricted someone from working in their industry, working for a competitor, because the restriction was so broad, that would be seen also as a non-compete. And also if it had the effect of preventing someone from leaving their job and going to another job, in the FTC's rule and definitions, they would define it as a non-compete and would violate the rule. Next slide, please. So the rule basically says you can't have non-compete agreements with employees after the rule goes into effect. So when September 4th comes around, if nothing happens in the courts, and we'll get to that, if nothing happens with an injunction, as this case winds through, and there's a few cases, and we'll tell you about that, but as the legal challenges to this rule play out in the courts, and it could play out for a year, 2 years, who knows how long, probably all the way up to the Supreme Court, the rule likely won't go into effect if a injunction is issued, and we'll describe that to you. But in any event, after September 4th, if nothing else happens, you can't sign up employees, workers, to non-competes. Now, there's some exceptions with regard to that for senior executives. So a senior executive, and it's defined as someone who essentially makes policy at a particular employer and is paid over a little over $151,000. That person can have a non-compete, but only a non-compete that pre-existed the enactment of the rule. So you can't sign a senior executive to a non-compete after September 4th, assuming nothing else happens here. But if they have one and it was signed before that, that will remain an exception until obviously that person leaves that particular employer, goes somewhere else, and they won't have to sign a new one. But the non-compete that's in effect for that senior executive is enforceable so long as it was signed prior to September 4th. Next slide, please. The conduct that this is meant to prohibit, essentially they use a justification under Section 5, as Carrie spoke about. Section 5, that it is an unfair method of competition for a person or a business to enter into a non-compete, or a business to enforce a non-compete, subjecting a worker to a non-compete clause. For senior executive, they say the same thing. It's also an unfair method of competition under Section 5, which the FTC says that gives them the authority to do this, to again enter into non-competes, to enforce non-competes, and to then represent that someone like a senior executive or a worker is subject to a non-compete clause, where the non-compete clause was entered after the September 4th deadline date. So that would be an improper action to say someone's subject to a non-compete after the rule goes into effect. Next page, please. So how is a non-compete defined? And it's on the screen in front of you. The rule defined a non-compete clause as a term or condition of employment that prohibits a worker from, or penalizes worker from, or functions to prevent a worker from seeking or accepting work in the United States with a different person, where such work will begin after the conclusion of the employment that includes a term or condition, or operating a business in the United States after the conclusion of the employment that includes a term or condition. So what does that mean? So broad that you can literally look at this and say, if someone leaves an employer and they want to go somewhere else, that's a non-compete. It doesn't go into detail to say, for example, and let's just use a research and development person. Person research and develops a widget. They do it at company A. They leave, they go to company B. They can't have a non-compete because they're leaving company A. They're going to company B, and that would be a non-compete. If, for example, you had a restriction that said, it doesn't prohibit you from going to company B, but it says, oh, yeah, you can't research the same product, the same widget that you research at company A over at company B. This is so broad that it would encompass that situation where a person is not prohibited from going to a different employer. They're not prohibited from working on or starting their own business, but this definition is so broad that even where you have a very limited restriction, that would be considered a non-compete clause. Next slide, please. As here, again, broad definition, can't seek or accept employment in the United States, can't operate a business. So literally, it places a limitation, anything that prohibits limitations on any work or any business startup essentially would violate this rule, which depending on your view of things and depending on what's being asserted in the various lawsuits that are already filed, may be too broad, may be overbroad, and we'll get into also if the FTC even has authority to do that, but that's the concern over the definition here. Next slide, please. When we talk about penalizes, were we talking about agreements that impose penalties on workers? So you leave and you have to make a payment, as we talked about before. $25,000 in liquidated damages, that's prohibited. That's a non-compete. Even though it doesn't prohibit non-competing activity, it penalizes a person for competing. Forfeiture for competition, same thing. An employee loses something. It could be a payment under severance, or it could be potentially equity, some sort of shares. Again, if it penalizes you for competing, even though it doesn't prohibit competing, it's covered by this rule. What's not prohibited are provisions that are not tied to activities post-employment. So there may be something else in an agreement that causes a person to forfeit shares or forfeit some kind of payment that would, if it's unrelated to non-competes, then it's not covered by the rule. Next slide, please. Functions to prevent, again, limits a worker's ability to compete. Any kind of restrictive measure that causes an employee essentially to not be able to leave their current employer, that would be considered functions to prevent. Non-solicitation provisions are not covered by the rule. Confidentiality, non-solicit provisions, so non-solicit of employees, non-solicit of customers, they are not barred under the rule unless they function to prevent someone from competing or leaving an employer. And so then it would roll under that, and they would say that that, again, is an improper method of competition, and the rule prohibits that. And next slide, please. Again, as we just said, the rule doesn't prohibit non-competes and non-solicitations. And what they're looking at is the functionality or the functional equivalence, that if you have some type of restriction that would, again, prevent someone from leaving an employer or prevents them from competing, that would be a violation of the rule. So I think that gives you a broad idea as to some of the things that are covered and are not covered under the rule. And I believe Kate will get into our next section.
Thanks, Mike. And nice to be with everyone today. Next slide, please. So I saw there was a question about who's a worker. And this is a long definition here, but it basically applies to all persons, whether they're current or formerly have worked for an organization. It doesn't matter what the title of the person is or the worker's status under state or federal laws. Doesn't matter whether they're paid or unpaid. Doesn't matter whether they're an intern, a volunteer, an apprentice, a sole proprietor, anybody who provides service to a business, either currently or formerly, would be covered by this rule. I think I saw another question that had to do with franchisees and franchisors. You can see that the rule you will see that the rule does not apply to a franchisor and a franchisee relationship, direct relationship, but people who work for the franchisee are covered, or work for the franchisor are covered. And I think it was already mentioned that workers do not include foreign workers who are working abroad, and they are not covered by this rule. The other piece that is addressed in the comments as well, that's implicit in this definition, I would imagine, is that workers that are hired by another entity, a third party, like a staffing company, for an organization, they are covered by the rule as well. Next slide. And this has been intimated at already by the previous speakers, that the FTC talks about really two categories of workers. A worker, as I've just described, and within that definition also is a senior executive. There's an exemption for senior executives, And the FTC itself notes how limited this exemption is. That there's probably about 1% of the workers in the country are estimated to be senior executives under the purview of this rule. And Mike, I believe, mentioned the salary requirement of just slightly over 151,000, a little less than 152. But the other part of this test of whether someone qualifies are the duties, and whether this person has a policy-making position. And the FTC follows the SEC guidance on this as well. And it really is driven by what the person is impacting in terms of policy. And the FTC points out, for example, and this mirrors the SEC rules, CEOs, presidents, or equivalent roles. So individuals that are actually driving the policy of the overall organization, not just particular divisions or subsidiaries or affiliates, and they refer to as the common enterprise of the organization. So it's a pretty limited exception. And the FTC clarified, as is noted on this slide, that C-suite executives and partnership partners would likely qualify as senior executives if they make significant business decisions. We've had a lot of questions about physician practices, partnerships, things like that. If the individuals and those partners in those organizations fall within this definition, this criteria, they would likely be exempt. Next slide. And this just goes to what I was just talking about. The policy-making authority means final authority to make policy decisions that control significant aspects of the business entity. And it goes on from there. So it's a duties requirement, not just a salary requirement. Next slide. So there are also exceptions to the ban, and they are either exclusions or exceptions. And I'll go first through the exclusion. There's a fairly long list here of banking, savings institutions, federal credit unions, common carriers, air carriers, foreign air carriers, and entities under the Packers and Stockyards Act are exempt. All those organizations are excluded from the FTC jurisdiction. I'm going to highlight just a couple of them now and not talk in depth about any of them. Banks are a tricky one. Banks are certainly not covered by the FTC's jurisdiction, but affiliates are. So it's very, whereas an established bank under the banking organization's chapters would not be covered, any type of sort of a separate arm of that affiliate or subsidiary would be covered by this rule. In addition, on the bank piece of this exclusion, the FTC notes in a footnote at page 45 of the comments, footnotes 262, points out that the FDIC governs banks, and basically points out that the FDIC may be reaching out and seeking to enforce this type of ban in that setting. The other piece to talk a little bit about is the nonprofit piece. We've gotten a lot of questions about this. Nonprofits are excluded, but not all will be free from the ban. And the FTC, and in fact, one of the commissioners noted this in the open hearing, this is a fairly fact-sensitive inquiry, particularly so in the healthcare industry, where there's a lot of mixed profit, nonprofit health organizations. So taxes and status will be one factor to be considered, but it doesn't overrule a further inquiry into the entity's operations and goals. Is it a profit-making arm, venture, co-venture, or joint venture with another entity? All of those things are going to be looked at by the FTC if this rule goes into effect. So it's something that will need special care to make sure that it doesn't fall under. I already mentioned franchisee and franchisors as not being covered by the ban. Some exceptions versus exclusions. And Mike, I think, covered a few of these. The existing non-competes for senior executives are not affected. Non-competes in connection with a genuine sale of a business and those enforced before the rule's effective date are exempted. We'll talk a little bit more about the business exemption in a bit. And importantly, causes of action for a breach of a non-compete that have accrued prior to the effective date of this rule, if it ever becomes effective, are not covered by this ban. So if there are lawsuits out there waiting to be filed for breaches, those are not covered and will not be covered until the rule becomes effective. Garden leave provisions, a specific mention of these types of provisions by the FTC as being carved out of the ban. And garden leave references the old garden leave types of arrangements in London where people would be paid to sit in their garden. And this is talked about throughout the notes in the FTC rule. It allows for this. They're not covered if the person remains employed. So still on the active roster, may not be coming to work every day, but is employed. And that it's okay to, and that person is receiving same compensation and benefits, even if it's on a pro rata basis for the time of the garden leave restriction. Next slide. So this is an interesting rule, and I'm sure one that the lawyers on this call will spend a lot of time thinking about and utilizing should this ban become effective. And this will be the creative and zealous advocacy skills of our fellow colleagues and lawyers. The final rule further provides that it's not an unfair method of competition to enforce or attempt to enforce a non-compete or to make representations about a non-compete where a person has a good faith basis to believe the final rule is inapplicable. I'm not going to go into great depth on this, and I encourage you, to the extent you want to spend some time with this rule, the many pages, 500 pages plus. At 350 through 352, the FTC talks about this and the reasoning behind it. And they state that they've added it in an abundance of caution to ensure the final rule does not infringe upon activity that's protected by the First Amendment. And they did it to clarify those rights. It's not an unfair method of comp to enforce or attempt to enforce a non-compete where the person has a good faith belief. They go into a discussion of the Noor-Pennington doctrine. Certainly, I'm not going to get in depth into that right now, but that covers filing a lawsuit, the ability to file a lawsuit, even if it may tend to restrict competition and ultimately is unsuccessful, is typically protected under the First Amendment of the Constitution. However, a key, however, courts have ignored that doctrine if the lawsuit is a sham and is objectively baseless and subjectively designed solely to prevent competition. So if this rule goes into effect, we all know that this rule will be invoked, or this exception will be invoked, or good faith basis. Be advised that, and you can read throughout the FTC, that when it's clear that a non-compete is banned by the very language of the rule, that this will not apply, this exception. If there's vagary, or if a particular section of the rule is subject to interpretation, perhaps. But we all know what the FTC's intent is here, and I would imagine this is a good faith basis defense that is going to be very, very limited. Next slide. So impact on state law, I won't read the slide to you, but the FTC rule is not intended, and it's explicitly stated, to impact state laws that restrict non-competes where the state law is consistent. However, if it conflicts, this is intended to preempt. So think about that. There are a number of states out there that ban or severely limit non-competes right now. California, Oklahoma, Minnesota, and North Dakota are full bans. There's probably 9 other states, and Washington, D.C. have income level, 25 states that have other restrictions, and 12 that have none. So this will impact some of those. It won't impact others. And as Mike pointed out at the very beginning, all of those laws are still in effect, regardless of whether they conflict at this point until this law goes into effect. Next slide. Interestingly, just like a good drafter of a non-compete or any type of agreement, the FTC has included a severability type of provision in the rule, which provides that if any part of the rule is held invalid or unenforceable by its terms, or stayed pending further agency action, or maybe stayed or impacted by one of these pending lawsuits that we'll talk about later, if one provision is impacted or stayed or found to be invalid, the rest remains in full force. So the FTC has covered itself here. If certain portions of this rule are struck down, but other portions are not struck down, the rest stay in effect. And I think next slide, I'm turning it over to
Yes,
speaker.
we had some good questions that came in. Mike or Kate, feel free to jump in on these.
Sure.
Does the non-compete ban apply to separation agreements?
The short answer,
Yes.
yes. In unison.
I'm glad we agreed on that, Mike.
And then it looks like there's some confusion about franchise agreements. Can you still have a non-compete in your franchise agreement?
No.
No. Yeah.
Yeah, I think the answer is yes. You can still have a non-compete in your franchise agreement. The rule is
Just not with your workers.
right. And then what about an offer letter where you, if the employee leaves, you have the employee needs to repay an award?
Yeah,
Go ahead, Mike.
that's a great gray area because there's no explicit prohibition for, let's just call it a signing bonus, or maybe there's some kind of training training allowance, something like that. But then if you leave, you have to pay that back. That would fall under the functions equivalent of a non-compete issue, that if the person was prohibited from leaving because they couldn't pay back the the signing bonus or some kind of training money they were given, they spent it all on Skittles. They can't pay it back, so they can't leave. If they can't leave, then the FTC interpret the language here. They would consider that to be a functional equivalent of a non-compete, and that would be improper. And that's a question a lot of HR people and business owners have serious questions about. Why would I pay a signing bonus to someone if I can't get it back and they can just leave? Or why can I give someone money for some kind of training or education, et cetera, and they don't stick around and they need to pay it back? A lot of questions about that aren't answered at this point.
So one question came up, Kate. So under the state law issue, are you saying that you need to comply with state non-solicitation law even if the FTC ban on non-competes goes into effect?
Yes. I am.
And then briefly, as far as enforcement, that's the slide that we're looking at right now. How does the FTC plan to enforce against companies that don't comply with the new rule?
Yeah, it's laid out here, Robert, on the slide. It's the FTC could commence an administrative proceeding under Section 5B, or they could proceed to district court and seek an injunction under Section 13B of the FTC Act. And they could seek to enjoin a defendant in federal court where the defendant is violating or is about to violate the Section 5 and seek an injunction in the public's interest. They've also set up a reporting mechanism on which is here in their compliance guide. Once the rule is effective, market participants can report information about a suspected violation. So sort of like a whistleblower line here. So there will be many ways in which the FTC can be alerted. I'm sure they'll be investigating and looking at particular industries or whatever their mechanisms will be to start bringing these actions if this rule, enforcement actions if this rule goes into effect.
Right, and I note that earlier this week on their website, the FTC put forth a compliance guide, and it looks like they've scheduled a webinar for mid-May. Compliance webinar. So that's something that you should, if you're interested, that you might want to sign up for. Next slide, please. And then as far as the implications of this new rule, let's jump into that next slide. Now, under the new rule, what type of notification requirements are there, Michael?
There's, as I said earlier, there's nothing to do right now at the moment, unless you want to prepare for September 4th. Although I'd submit to you, I wouldn't tell you not to prepare, but I'd submit to you there's at least 3 court cases already. There's injunctions being sought. I frankly wouldn't get too crazy. I would stay calm right now and not do much. But as far as notification, there's a discussion in the rule about rescission, meaning does an employer have to rescind their non-competes? or how do you give notice? And ultimately, the FTC came down on the idea that an employer needs to provide a written notice to all their employees, or at least to specific ones covered by agreements that says they are no longer going to be enforced. They have some specific guidelines that the notice should be sent to last known address. They should be sent to email account. It can be sent by text message. There's a lot of different ways you can do that. Next slide, please. The FTC, they've given you a model language you can use. And look at that, a gift. In every rule, there's a gift. Here's the gift. They give you some model language, though it doesn't appear to be required, but they do give you model language that you can use. That's on the screen in front of you. That basically says you can't. They're not going to enforce a non-compete. The employer won't enforce a non-compete against you. You can take a job with a competing company or any other company, even if they compete. And it's interesting when you look at that language that you can take a job with any company, even if they compete, kind of plays into that idea that you, according to the FTC rule, you can have an illegal restriction if a person simply wants to leave and go to another job, even if it's not with a competitor. So like you said, there's a very broad definition here. You can start your own business, the notice can say, and the notice would say that you can compete. Of course, it then also says it doesn't affect any other terms of your employment, which, of course, there'll be all kinds of questions about that. For example, you give someone money for education. And you have a provision that says if you leave before 2 years, then you need to pay us back because we sent you to business school, or we sent you to welding school, or wherever we sent you. That potentially will be problematic and subject to questions because what does that mean exactly? And is that really operating as a non-compete? Because if a person can't afford to pay back the money they've received and they can't leave their job, is that really what this rule is meant to handle? And that would be obviously to employers. Why would an employer want to pay for education or give signing bonuses if they can't recover them if someone decides to leave 6 months after they join their organization, and then they say, well, I can't leave because I can't pay it back. And so that violates this rule. Again, broad rule, a lot of questions. There'll be potential litigation over that. If you go to the next slide. You can send an all staff email to everyone, laying out the model language, laying out what we just talked about, that non-competes won't be enforced. You can go anywhere you want and all those sorts of things. It's not super specific as any kind of requirement that has to only go to people that have non-competes. Just recently, California, they have a rule that after January 1st and by February 14th, employers had to give notices about void non-competes and those sorts of things. This actually is a little more forgiving on that front as far as the model language and what's required. Which now brings us, sorry, Robert, yeah.
Yeah, so with respect to the notice, they have model language on the FTC website for the notice. And practically speaking, if the rule goes into effect, the notices need to go out by September 4th. Is that right?
Yeah, compliance has to be given by September 4th. So right. After September 4th, you can't enforce. So you would have to send out the notice. You could send it out by email the day before. You could send it by mail, text message, etc. A couple of days before and say effective September 4th, for example, the following applies.
Okay. And so then it's going to be important in tracking the litigation and the injunction requests. Clients are going to need to know what type of agreements they have, whether they have non-competes prior to this compliance deadline, right?
Correct. If you want to do something to be on top of your game, one, check your agreements, make sure you have good confidentiality agreements, good trade secret protection agreements, make sure you're taking proper measures to protect information. Take an audit of what agreements you have and with who, so you know who your pool of people are that you need to potentially do something with. And then you may want to start, and we'll get to this later, but you may want to start using some other ways to protect information. Maybe you want to use a garden leave. Maybe you want to use a term agreement. There are some other tools that you can use which are permitted, and we'll have some discussion around that later in this presentation.
Okay, great. We're getting a fair amount of questions about the sale of a business exception, so this might be a good time to transition over to Susie, who's the chair of our M&A practice, and she's combed through the rule and tried to highlight the key aspects of the rule as it applies to business deals. So next slide, please. Let's turn it over to Susie Saxman for her discussion of the M&A impact.
Great, thanks, Robert, and thank you everyone for joining the webinar. Next slide, please. I think we've gone one too far, perhaps. Now, here we are, great. So broadly speaking, the final rule that was issued last week by the FTC does not impact the enforceability of non-competes generally, but they base that on whether or not there's a bona fide sale of a business or a person's ownership in a business entity. And there's a bit of discussion in the final rule that was issued in the commentary on pages 340 to 342. Initially, when the proposed rule was issued, the FTC had suggested that they would allow non-competes in the sale of a business for employees only, or for workers, perhaps I should say, only if they own 25% or more of the target business. And apparently they received a fair amount of negative comments that persuaded them that the threshold was either too high, it failed to really reflect that a worker with a lower threshold, in fact, might be able to have significant goodwill and be able to enter into a non-compete. There were some other thresholds that were thrown around, and you can read about those in the FTC commentary. They really simply declined and are kind of pegging everything on whether or not there's a bona fide sale. And there's a fair amount of discussion, even on just those few pages that the FTC goes through, but it still leaves a lot of unanswered questions. So one thing that the FTC does make clear is that the exemption does not require a minimum amount of proceeds to be realized by the seller. They don't set that as a bar, but they have commentary indicating that in order really for the non-compete to be enforceable with a worker, you've got to have two independent parties to the transaction. The seller has to have a reasonable opportunity to negotiate the terms of sale. And this is one of those analyses that is really going to vary wildly in deal to deal. You may have a closely held business where the management team, say 4 or 5, maybe 6 people own the business. Everybody's involved in the process. You may have another deal where you've got that same group of owners, but then perhaps you've got another list of say 20, 25 owners who've got small percentages, very small percentages, and they're not involved in the negotiation of the deal. I think you're going to find that smaller group of individuals who can't demonstrate that they were exposed to the deal, involved in negotiation, participated, I think it's going to be tough to enforce those non-competes. And I think what we're going to see just in M&A generally is, as opposed to the one-size-fits-all approach, which is fairly common, almost no matter what the size of your deal is, I think you may start to see more of the nuanced treatment where owners with X% or more will have certain non-competes. Perhaps those with smaller percentage will have different type of restrictive covenants, or perhaps a shorter non-compete. I actually see that today in some situations where, listen, we can't pose this level of non-compete or a non-compete at all on individuals who have such a minuscule portion that they're really not going to be seeing the type of sale proceeds, either short or long term, that the other owners are. So we're going to have to see how this plays out. Let's turn to the next page. In addition to the sale agreement itself, which is often where a non-compete appears, or perhaps you've got a separate restrictive covenant agreement that's attached to that gets entered into at the time of closing, there are a whole variety of other M&A related agreements which are likely going to be impacted by this FTC rule. You've got equity incentive plans. They frequently, if not always, have restrictive covenants, sometimes non-competes, perhaps not all the time. There may be retention or change in control agreements that get entered into. I would say they more often than not have non-competes associated with them. Rollover equity agreements. So what's a rollover equity agreement? Frequently, if there's a private equity buyer of a business, they may say, we're going to buy the enterprise, but as a condition to this, we want you to sell, say, 80% and then contribute the additional 20% in a rollover, ideally a tax deferred rollover, so very attractive. And effectively, you become an owner in the buyer's entity, and you will then realize proceeds and other benefits during some period of time after your initial sale. And it may be when the business, as rolled up with other acquisitions, gets sold, say at the end of another 5-6 years. Very, very frequently, those rollover equity agreements also have non-competes and other restrictive covenants. And then, of course, there are just the garden variety executive employment agreements. I think it's pretty clear in the executive employment agreements that's a no-go. I mean, the non-competes are going to have to go to the extent you did enter into an executive employment agreement with a non-compete for an individual at a policy level making over the threshold income in the past prior to the effective date. So we're really talking about September 4th. You'll still be able to enforce those, but on a go-forward basis, purely in the employment agreement, we're going to have to stick to a more nuanced non-solicit of customers, employees, independent contractors, and confidentiality. And I think that a couple of alternatives that have been mentioned that we're going to start seeing more of is the concept of garden leave. Now, there's a cost to that, obviously, in order to keep somebody on the payroll and effectively keep them from competing. You will continue to pay them. I think we'll see some of those, maybe not for long periods of time. Maybe the fixed duration employment agreements, perhaps those fixed duration will go through the period of an earnout if there is one, for example. You may be talking about a 2 to 3 year period. I think one of the things that we really just don't know enough about, it's really open, is to the extent that there are these springing non-competes that arise in the event of a repurchase of an individual from a company, either on a one-off basis, independent of a real M&A transaction, or subsequent to an M&A transaction. So somebody holding rollover or new incentive equity. Are you going to be able to impose a non-compete in those situations? I mean, the FTC seems to be commenting that they don't necessarily think those situations are going to be bona fide sales for the purpose of non-competes. But the two factors that they call out is there goodwill exchanged by the employee at the time? And did they have knowledge or ability to negotiate? And that's going to be on a case-by-case basis. One of the things I wanted to mention too, Robert and others mentioned that this week the FTC issued some guidelines, and number 13 in the guidelines says the rule doesn't apply to non-competes between the buyer and seller of a business. We've just talked about that, or potentially the seller's share of a business. And they then go on to say that the seller can agree to non-compete individually, but not for any of the business's workers, and the rule prohibits non-competes for workers, including in the sale of a business. What they just don't seem to fully appreciate is often sellers are workers. I mean, we see that particularly in middle market and lower middle market transactions. You may have sale transactions where literally every single seller is an employee of the target company. And I think probably the nuance is going to come in. Are they big owners? Are they influential owners? Are they involved in sale and negotiations, or aren't they? And then finally, just one point I want to make. This rule doesn't limit confidentiality or non-solicitation agreements. And for a fair number of companies, they may simply decide it's just not worth dealing with the non-compete. They'll have finally, drafted and negotiated non-solicits and confidentiality, and they'll go with that. I don't know whether that'll impact the price or not. We'll have to see.
Great. Susie, anything else from a merger and acquisition perspective?
Only that I think, this is gonna have a little bit of a different impact, I think, depending on the size of the M&A transaction. And I think whether you've got private equity or strategic, I think we're gonna see, I tend to see a little bit more one-size-all approach for private equity. I mean, that's obviously a broad generalization. They often have, very well prepared templates. They've got a framework in place already. They don't necessarily want to negotiate some of the documents that what I'll call your worker sellers are signing independent of the purchase and sale agreement. So I think, time will tell on some of these issues.
Good. I think you answered this, but just so we had a question on this one. Under the bona fide sale of a business exception, what if a key employee is not an owner but gets a huge sale bonus out of the deal with a non-compete? Would that key employee signed at the closing be enforceable if the rule goes into effect?
I wouldn't think so. I would think that that's in the nature of an employment bonus. I mean, what's your take on that?
I agree.
Yeah, I don't see that as being sale proceeds. Even
All
though
right.
it's obviously in connection.
We're getting a lot of great questions, so I'm sure as I comb through these, I'm sure I'll be back to Susie during our general Q&A
Sure.
session. With that, let's turn it over to Mark Fossey, who's our employee benefits specialist. He's going to tell us about the impact on employee benefits if this rule goes forward. Next slide, please.
Thank you. And one more. So employee benefits, of course, is a very broad group of benefits. You can have health insurance, disability, 401k, life insurance. And these types of benefits traditionally do not come with non-competes. So we want to focus in on the type of benefits subject to ERISA that do come with a non-compete. And one of the first ones is what I call a top hat plan. And that's because under ERISA, there's a specific rule that if you provide a retirement plan that's unfunded and is primarily to provide deferred compensation to a select group of management or highly compensated employees, then it becomes exempt from a lot of ERISA. But also, even though it becomes exempt from a lot of ERISA, it still retains the preemption provision, which is in section 514A of ERISA, which under that, it says that ERISA preempts any state law that relates to employee benefits. So, it's clear that a top hat plan is considered an employee benefit. It's covered by ERISA, so that preemption would apply. And it's been an area where, even if a state law prohibited the non-compete provision, you could put it into one of these ERISA plans. Another area where you see that is in severance plans. And the issue, though, is that under 514D, ERISA also explicitly says that ERISA will not be construed to alter, modify, impair, or suspend any federal law. So while the case law clearly shows that, ERISA applies to these types of benefits, that ERISA governs, forfeiture of benefits, vesting of benefits. It doesn't, explicitly regulate or talk about non-compete provisions in it. So currently, if the FTC rule became effective, right, ERISA wouldn't preempt it. And so, even if there's a conflict between those two, because ERISA has a specific provision that it doesn't preempt it, this will probably be litigated, but it's most likely that the FTC rule would apply in that area. And so that's one of the things that employers would need to get ready for. is if they have had these types of agreements in place. Now, there is, as people have talked about, the exception for senior employees. So, you could look and see which of your employees would be senior executives, and, their plans would be grandfathered. But if your plan's more broad-based, then, this may apply, and you may have to provide notice and wouldn't be able to enforce those. Now, we called it a top hat plan. And so top hat plans, we already are a select group, of management. But that definition, I would say, is generally broader than the definition of senior executive. So an employer can't just think, well, this is a top hat group. It's only, management, highly compensated employees. So those should all be grandfathered. If this is going to become effective, that is something that employers are going to have to look at, is, who is in that group. Same thing with a severance plan. Severance plan doesn't have to be for a top hat group. It can be for a very broad segment or all of an employer's population. And so you'll need to look at that also. Potentially, you could create a separate severance plan for senior executives before the effective date, to try and have that be, a grandfathered severance plan for those individuals. I have on here 457F plans because as we've already noted, the rules aren't applicable to nonprofits. So under 457F plans, you have an ineligible deferred comp plan, it's called, and that's what nonprofits can put in place to have deferred compensation. And so the FTC rule wouldn't apply there. And not typical, but under the proposed 457F regs, a non-compete period, right, can serve as a vesting period. So, for example, an employer could offer, $200,000 if you comply with this vesting period over 3 years or 2 years after your employment. And so, some companies have put those in place. And so, you would need to look at, are we a bona fide nonprofit? I know that's kind of an odd thing. I was thinking, oh, it's just blank, you're nonprofit. But the FTC did mention that they would be looking at that, in particular in the healthcare industry. But in general, you wouldn't have to worry about it with your 457F plans with respect to the FTC rule. All right, next slide. Another area kind of for employee benefits is equity compensation. And I think, we already discussed that frequently there are non-compete provisions in equity compensation. When there are non-competes, there are different kinds of non-competes. There's the kind of what I would call the full restrictive covenant. And under that, you can enjoin someone, right? You would have the right to enjoin them. They couldn't go to the competitor. Then there's the forfeiture type of restrictive covenant, where if you do it, you're going to lose a benefit. And so, we have to analyze those also, because the rule says penalize, right? So, for example, if you were going to retire and the company said, we'll vest the remainder of your 25% of your options if you don't compete over the next year. So, you're like, oh, well, they're earning something. But I think that the FTC may look at that as a penalty that would, at least discourage you from entering in certain areas of the market or starting your own business. And so we're going to have to look at those provisions. Also, if you look at your agreement, because if your non-compete becomes invalid, how does that affect all your other restrictive covenants, right? It was pointed out that many of the other restricted covenants can still be valid. So, do you have a severability clause to analyze if your non-disclosure, if your confidentiality, non-solicitation provisions will remain effective, and potentially there could be vesting for those for keeping those restrictive covenants. Let's see. So the other area where we see these a lot is in employment agreements, and it's a lot similar, the same analysis as your equity compensation, right? And that's where we frequently see these different restrictive covenants, and I think that employers need to think through what in those restrictive covenants, are we going to maintain? Sometimes I look at the non-competes and I think to myself, well, non-competes are very popular because they're like an easier way to protect your trade secrets, right? If the employee was going to leave and you could just, scan and just remove your trade secrets, you might not care as much where they went to work, right? But you can't. And so, by non-competes, you just kind of keep those individuals from going to work where your trade secrets would be very valuable. So, now we still need to try and think about, how are we going to protect those trade secrets in this world where we don't have this, easier tool to protect those trade secrets. And so I think that's going to be a big thought process in employment agreements and in restricted covenants for how we're going to go forward. There's not a lot of time here, but I wanted to mention there are other areas where this can create changes. For example, under Section 280G, the amount when you're trying under Section 280G is for golden parachutes, and if you sell a business, have a change of control, and if you're paid 3 times more than your compensation the year before, then you may have some penalties. And so you have to determine what the amount of that compensation was. And it used to be that the accountants or whoever was determining that would say that part of the compensation that you are receiving that's reasonable compensation was the value of that non-compete. And so, of course, if that became, and so you get to carve that out as reasonable comp. So if you can't have a non-compete anymore, then that would affect the calculation of the amount that's determined when they're going to see if you have excess parachutes or, parachute payments.
Very helpful, Mark. I think I'm going to ask Kate and Mike to bring us home so that we can have a robust Q&A. Kate is going to tackle compliance strategies, and then Mike is going to give us a brief update about the legal challenges. I think we should set the table with some sort of real pertinent questions that employers are asking Kate on the compliance side. Should I stop using non-competes right now as a result of this rule? And number 2, should I try to enforce my non-competes right now if I have somebody that's violating them? Next slide, please.
Yeah, no and yes, to be quick. No, if you have a non-compete in place and it's it's compliant with state law, and you have someone you believe is violated, you should enforce your rights. They are still on the books under state laws. And I would encourage you to not walk away from your rights and not enforce them. And what was your second question that I already answered?
Should I stop using non-competes?
Yeah.
Pending what happens with this rule? Yeah,
I would not. I think obviously this on everybody's mind. It's on the radar. If it's something you're about to roll out, you know that there's a possibility this rule may go into effect. We all, I think, agree on this call, or at least I'll speak for myself. We think this is going to get enjoined. I'd be surprised if it doesn't. And I think it's going to be tied up in litigation for a long time and make its way to the Supreme Court, perhaps, to resolve any conflict that turns out in the circuit. So I would, and I think Mike mentioned this at the beginning, I would stay calm and enforce your rights and continue to do what you've been doing. But think about what may be coming and some of the tools you may be using already, and then we'll heighten the importance of those tools will heighten if this does go into effect.
Well, in the next couple of slides, could you highlight for us some of the big picture sort of takeaways?
Yeah, sure. Can you go to the next slide, please? And we've talked a lot about this, and there's great minds on this call. There's great minds around the country thinking of ways around this rule. And so I'm not going to. We've already talked about non-solicits and some of these already. And of course, you have to comply. It can't function to prevent someone to go work somewhere. So I'm not going to get into the details of that. Some of the things we haven't talked as much about. Retention agreements. I think Susie, you mentioned it. The FTC points out, in addition to retention agreements, and of course, this is, I'm going to, treat your employees well, and they won't leave. I think that's a little naive, but that's one method. And then, of course, retention agreements that pay someone to stay. The question is, what happens if they leave and you've already paid them? They don't really address that. I imagine you could go after the money and bring it back, but you can't force someone to stay employed. I think that probably is a violation of the 13th Amendment. So I think those are things to be thinking about, but Lord knows how all that's going to play out. Mark references trade secret protections and strong NDAs, always important, will be even more important if this rule goes into effect. Trade secret programs that are looking at your trade secrets, identifying them, making sure that you have proper protections in place from a technology perspective to training, to teaching, training employees as they come in the door, to employees that are leaving, departing, making sure that they know that they can't take things with them. NDAs we've mentioned, these are under the microscope already. I think Carrie mentioned this, the NLRB has got their oar in the water in this area, not just in non-competes, but on NDAs. There's a lot of discussion around them. They can't be so broad as to prevent people to go work from somewhere else, but also to suppress and inhibit protected activity under the NLRA. But those are still strong tools if they're drafted properly. Garden leave, we talked a lot about that. I did see a question in the chat about is there any indication of how long those can be in the FTC? I didn't see any reference to that in all the discussion. But again, how long are you going to pay someone? And the question is, how long will someone stay? So I think that's going to play out. Fixed duration contracts, specifically mentioned, or term contracts are mentioned in the FTC. I guess you could have a 3-year term and have a non-compete in there, and it's going to act very similarly as a garden leave provision, I think, in my view. I don't see much difference in the two, but those are things to think about as well. I would go to the next slide. And just to highlight some things that we've already talked about, make sure you're talking with employees now, making sure everybody knows that non-competes are still in effect, they're still on the books, they're still enforceable. Take a look at your agreements and policies. This rule would impact those if they go into effect. So if you have particular provisions in your handbook or your code of conduct that would have the impact of a non-compete, you will need to revise those should this rule become effective. We've already talked about number 3. Keep an eye on obviously the legal challenges. Mike will talk about those in a few minutes. I think, I don't think anybody should panic at this point, but I do think it's prudent to prepare a list of people, in particular if you're a large multi-jurisdictional employer. It will take some time to gather that information, to be prepared to send notices if you have to. So why not get started? It's also a good time to audit these agreements to make sure they're, signed and effective, or don't need to be updated with all of the myriad of state law updates across the country. Next slide. And again, another opportunity to make sure your agreements, which are governed by state laws, are in fact compliant. And then finally, take a look to see who would qualify for this senior executive exemption. I think it's going to be a small group, given the test and criteria that we described. And if you have a senior executive that falls into this criteria, and you've been thinking about getting them to sign a non-compete, now's the time before this rule becomes effective, if it ever does. You have them sign it now. Of course, there can, additional consideration rules across the country. Most states require additional consideration if you present a non-compete during someone's employment. So take a look at that as well. Mike already talked about the model language, and again, do not send notices right now to get ahead of the curve, because once you send it, arguably there's a contract or implied contract that this agreement that's in place has been revoked.
We got a question about how does the notice compare to the California requirement? The notice under the FTC rule is a little bit more lenient. You can do it by email or text message, or you can do it by hand or mail. So that there's a difference. And then just briefly before we let Mike go, Carrie, could you, as far as messaging to employees, because I know from a labor perspective, employees are asking, I heard that my non-compete's no longer valid. Why are you guys using non-competes? What's the messaging that employers should be thinking about if employees are reaching out to them about this rule?
Yeah, thanks, Robert. I mean, not to give the lawyerly answer, but I think it depends on who's asking. I mean, I'll break this out into sort of two buckets, and I'm going to use the word unsophisticated as a term of art. It's lower skilled, lower wage workers who tend to be subject to non-competes in certain industries, and that's really who the National Labor Relations Board General Counsel is going after. And I think that we can just say to them, this is not law yet. We are monitoring these developments, and if we have something to discuss with you, we'll let you know. And I think that the messaging to other folks who at the very least might be covered by the act as well, who might be in an engineering or higher level sales role, is really along similar lines, just that, as of now, this agreement remains valid, and we will continue to watch the law, and we will discuss with you any changes that need to be made. And I think that's a broader messaging that we can apply to most employees as we go forward here as well.
Agreed. Hey, Robert, can I add one piece too? Because I saw a question on this and it's relevant to what I was talking about in terms of tools and other things to do. Someone asked about no recruit, no hire agreements. And the FTC specifically said that those are covered by this rule if it goes into effect. And keep in mind, no recruit, no hires are also subject to antitrust regulations and laws, and query whether they can be part of a settlement in a dispute. There's been discussion about that and disagreement about that previously, but I just want to make sure we address that question.
Okay, great. Mike, why don't you give us an update on the current legal challenges of the FTC rule? Next slide, please. Next slide, please.
Because we are cutting edge here at Seyfarth Shaw, breaking news, which is going to kind of ruin some of the slides I have here. But Judge Barker, in the U.S. Chamber case, there are 3 cases filed. One was the Ryan case, which was the first to file. Then hours later, the U.S. Chamber filed, and then I think a day later, the Tree Service filed. First 2 being in Texas, last one being in Pennsylvania. In the U.S. Chamber case, the judge just issued an order moments ago staying the U.S. Chamber case in favor of the Ryan case under the first to file doctrine, which is a very strong federal doctrine. So that's going to change the deadlines and landscape. So when we were telling you, I think earlier we said by June 19th, the Chamber of Commerce case will be decisions in that case. And that the Ryan case was actually, the scheduling is a little different behind that. We may be right, we may be wrong, remains to be seen, but breaking news here on your seminar. Next slide. The rule from the FTC is being challenged on several grounds. Federalism, does the FTC have authority to actually regulate in this area? In the last 50 years or more, the FTC has never regulated in the non-compete space. Although, ironically, when they issued the rule a little over a year ago, they issued the rule, they had remarkably 2 enforcement actions against 2 small companies in the Midwest, saying that, oh yeah, we enforce in the non-compete space. So query about the timing of those actions. But in any event, the cases that have been filed already essentially fall into similar categories. They challenge the authority of the FTC to do this. They say that the non-compete rule, in fact, is unconstitutional because the FTC has not been delegated that authority by Congress. They say it violates, well, I get them. It's arbitrary and capricious, the rule, because the rule itself has a lot of ambiguities, has a lot of unknown areas. It just based on the questions we're getting, there's a lot of things that the rule just doesn't tell us how to respond. Next slide. And by the way, a couple of you have asked, the CLE code will come in a few minutes here as soon as we're done. The rule challenges, I'm sorry, the cases challenge the FTC's authority, as I mentioned, under Section 5 and Section 6 to regulate unfair methods of competition. It challenges under the major questions doctrine, whether or not in issues that have extreme economic and political significance, that is the agency, these non-elected officials, able to interpret and do these things for essentially the entire country, which on the other hand, Congress was elected and others were elected to carry out these things. Next slide, please. The issues of federalism and delegation of authority, is Congress is the one who is delegated the authority to deal with these issues, as opposed or states, as opposed to one 5-person committee that's appointed. So again, these are the general issues that these cases are all questioning, and one could say that cases were filed in certain circuits, federal circuits, because those appellate courts tend to lean in a particular way with prior decisions. The Supreme Court has a prior decision in this area, not with regard to the FTC, but with regard to the EPA. There's a West Virginia versus EPA case from 2022, Supreme Court case where essentially they said the EPA overstepped its authority, obviously not non-competes, but the similar situation here. So one might say that more may foreshadow what's going to potentially happen before the Supreme Court. There's also Chevron doctrine, which also talks about the authority of Congress and the delegation of authority to agencies and what they can do and and the issues of transparency and what these areas can, what these committees or these bodies can actually regulate. So those are all questions that will be answered by these cases. Next slide. Again, you can see here a lot of these issues we've talked about generally. These are just more specific regarding the arbitrariness of the rule, the economic impact, and the retroactive consequences of these rules being put into effect on businesses and workers who have agreements, they have litigation in place, they have a number of things going on, and this is potentially invalidating those things. So again, these questions will all be answered in the courts. As far as what happens next, I suspect in the Ryan case, that court will set a briefing schedule and that will proceed. I suspect the chamber will consider whether they will essentially intervene and become a plaintiff and a co-plaintiff in the Ryan case. And that one then will proceed most likely in a similar fashion. There's an injunction issue pending before both courts. There'll probably then be summary judgment. Those most likely will be combined, much as it had been done in the U.S. Chamber case, which is now stayed. And the same sort of procedural issues will take place most likely in the Ryan case that were going to take place in the Chamber case, which already had a schedule set. Next slide. What happens next? This slide's a little outdated as of 10 minutes ago, but again, cutting edge here at Seyfarth Shaw. We're giving you up-to-the-date information. But as I said, the Ryan case will likely set a schedule. The chamber will probably intervene into that case. Question will be what happens with the tree services case. It's in a different forum, and there were some motions filed actually in the U.S. Chamber case by the FTC talking about who, if the courts rule in these cases, who those rulings might apply to, as opposed to applying to members of the chamber or only the business that brought a lawsuit. those are questions which the courts will have to answer, and there may be conflicting opinions between the Eastern District of Pennsylvania and Texas. We'll have to see. So the case will ultimately go to the Supreme Court with such a significant issue, as well as potentially split among the circuits. So,
Mike, with that, why don't
yeah.
we go ahead and jump into some questions?
Great idea.
Let me give you everyone the CLE code. It's SS as in Seyfarth Shaw 3647. And if you could go back one slide, please. We've been following the FTC rule. There's a number of management alerts and blogs on our dedicated trade secret blog. So if you want to stay current on the latest and greatest, go to tradesecretslaw.com. With that, let's jump into some of the questions. Mike and Kate, monetary penalties or fines if you violate the rule. My perspective on that is that the FTC is actively encouraging employees to report employers. They're acting businesses to report competitors. And then the way that that will be played out is that they would typically seek injunctive relief, and that if you don't comply with the injunction, you could get contempt fines and citations. Do you generally agree with that, or is there some nuance?
I agree with that. I haven't seen more commentary or specifics in the FTC rule that talks about specific monetary penalties other than what you've just described.
And if you look at the consent decrees they obtained in those two test cases a year ago, that doesn't give it that much guidance either, but it does deal with the covenants themselves. So hard to say, but the statute, the rule doesn't really tell us yet.
Here's a good one. I think that it reflects sort of the harshness of the new rule. Someone's asking, if I have someone that's been being paid a regular non-compete amount each year, does this new rule impact that existing agreement? And do I have an obligation to pay that amount? They want to go after
Depends.
Sure. Yeah, it depends. I think all of us would have very different answers coming from our different disciplines. I think from a contractual basis, if the statute if the rule then made that payment non-obligatory, then it's possible that that person could get out making that payment. On the other hand, if the person wants to continue to make the payment, I suppose the person still working there who's getting paid, that could look like a garden leave situation. We don't obviously know the terms of the agreement, what else it says, and we're not giving individual legal advice here, but it could be a situation either way, depending where you want to come out.
Does anyone have any thoughts on deferred bonuses and forfeiture provisions on deferred bonuses and how this non-compete ban would impact those generally?
I thought the FTC said some of those bonus payments not getting paid that would be okay. At least that was my read. I'd be interested in other people's view on that.
I agree. I think if it's if the policy says if you go to a competitor, you forfeit your bonus or you have to pay back your bonus, that's highly problematic, violates it. But they could be structured in a way that if it's not tied to leaving, it could work.
Right. I mean, I generally don't ever see those restrictive covenants just have a non-compete. I mean, it's a whole series of restrictive covenants. And so the question is, if just the non-compete portion becomes, invalid, how does that affect the whole agreement? How does that, does it void the whole agreement? Do you no longer have your payment obligations or your repayment obligations? I mean, you're gonna have to look at your agreement.
I agree with you, Mark. It's never just the non-compete. It's always the non-solicit in addition to that, because everybody is always concerned, is the non-compete going to be enforceable? But just under state law. But the non-solicits are more likely to be enforceable.
And Kate and Mike, I think we looked at this morning. There's a question about, oftentimes there may be state statutes that deal with requirements about state workers. Conflict of interest type policies. does this non-compete rule, you know, apply to those state employees in that context, and sort of contravene what may be in these statutes about, you know, conflict of interest policies about holding office or whatnot?
I think the FTC would say, well, that serves as a non-compete, but the purpose of those rules, and private businesses have them too, but the state rules, those are anti-lobbying, anti-peddling interest statutes. They're not meant to prevent competition. They're meant to prevent someone capitalizing on their job at a state agency, go to a private sector, and then start lobbying or engaging certain contract negotiations or applying for things. I think it's very different and it shouldn't apply. I just suspect, and Kate, tell me what you think. I think the FTC would say, oh yeah, that applies to that too.
I think it does apply under the FTC's intent and language of its rule, but I agree they're very different. They're distinctive statutes.
Well, I do think that there is some, I think it's worth, I mean, this rule is very dense. It's like 500 pages. I do think that the FTC does acknowledge that there may be some exceptions for those types of rules, whether it applies to private businesses or if it's just government, state and government local officials and their particular rules about holding offices or interacting with contractors. I think they are at least talking about that it may not apply.
Yeah. TBD.
Yeah.
Like so much.
I have some questions about the senior executive exception. What if right now the person doesn't qualify as a senior executive, but prior to you know, the effective date of the rule, they may? Any suggestions in that regard?
Yeah, I think, you know, again, until this rule becomes effective, you're looking at what the situation is when the agreement's signed. So I think if you've got someone on the cusp and you're thinking of promoting someone into that type of role and you want to non-compete for that, now's the time.
And I think this question highlights a key distinction in the rule. Let's say on September 5th, that person becomes a senior executive, but prior to that time period, they were not a senior executive. The fact, just because that now, as of September 5th, they're a senior executive, can you have a non-compete with them?
I doubt it.
Right. So
Great.
that September 4th is sort of a magic
Yes.
you know, dividing line. Yeah.
Yes.
And that's the reason to do some of the prep work. You know, again, maybe the litigation will delay that date, but it's not necessarily just notices. It may be other operating actions.
And then a question on the notice, can it be a blast email or do you have to individualize the email on the notice?
It can be a blast.
Yeah, it's expressly says
Yeah.
you can blast everyone. Yeah.
Now, what about a passive partner or a passive equity owner? Does this non-compete ban apply to them? Maybe that's for Susie.
Well, this is where that individual is a worker.
Yes.
Well, I mean, I think the issue is going to be, is it triggered by a bona fide sale? I mean, I think if you've got a low percentage owner who's, you know, never had anything, it was kind of take it or leave it here, everybody signs this, I think it may be tough. But I mean, there's still a lot, I think, of clarification that has to come over bona fide sale exceptions.
And here's an easy one. Does the new rule apply to independent contractors?
Yes.
Absolutely.
In a word, yes.
Staffing agencies, a
Yeah.
lot of shared service companies, for example, that larger conglomerates have. I mean, all those people are going to be covered. That's why they tend to use that word worker.
Worker, yeah.
Yep. They're focusing definitely on just the broader
Mhm.
generic.
I like that they said intern. I've never seen an intern with a non-compete, but apparently they are covered.
These questions are very creative, and I don't know that there's definitive answers yet. There are a lot of questions on the garden leave. What about a garden leave, but it's the full discretion of the company to waive the non-compete within the garden leave upon separation?
I would think that'd be okay, but I'd be interested in other people's views.
I agree with Kate.
Yeah, why not?
Right,
Yeah.
if I'm going to pay you to stay on, I can just as easily say, don't stay on. And if I
Right.
say, don't stay on, I'm not paying you, there's no non-compete. So,
Right.
yeah.
But I think a key distinction is going to be like when you have this garden leave, what if the employee balks? And I think you spoke to that, Kate. What if the employee says, no, I'm not going to stay, I'm leaving now?
Right.
What would your remedy be?
Stop
If
paying.
Stop paying, and if you've paid some already, I suppose you could seek to get it back, but that may be a challenge.
And,
Hence,
and if you're talking about a term agreement, Robert, where we can't make someone stay on. I mean, this differs by state, but there's a general rule. The majority would say you can't make someone stay on. And if they leave, you can't stop them from working for a competitor legally, even in a term agreement. But you could, under state law, potentially get damages. But this this rule will call that into question, because the last state law says you can get damages if someone violates a term agreement. But if they're violating a term agreement, it means they're working at a competitor, potentially. If it's just limited to the term, I'm not fulfilling my term obligation. I think the FTC would say, well, that's a non-compete because you can't just go wherever you want. So again, you're going to have to see how this plays out at courts. And then if this went into effect, you're going to have this issue where someone has a term agreement and you go after them, and well, no, they'll say you're violating this FTC rule.
And then finally on the Ryan case, as far as timing, if you could look into your crystal ball, when do you think we're going to hear about whether this injunction is going to be issued or not?
I think there was I quickly perused the decision, the cutting edge that we reported on here. I think on May 7th, there's a deadline for the FTC to, I'm sorry, I think let's see, May 7th. The FTC has until May 7th to say why or why not it opposes expedited briefing on the matter. So I think within a few days, we'll understand the schedule from the Ryan matter, because that is before the court right now.
All right, great. I think we've answered most of the questions. For those that we didn't get to, we can follow up, and then feel free to reach out if you have any additional questions to any of the panelists. We wanted to thank you for your time and attention. This is going to be an interesting process as we navigate this new groundbreaking rule and closely follow the litigation filed related to it. Again, for those that didn't get the CLE code, SS3647. I'd like to thank the panelists for their insights, and thank you all who attended today. Have a great rest of your day.
thank you, Robert. Thanks, everybody.
Thanks, everybody.